Dalzell.
Follow on from the comments that my colleague Trevor Mallard made, because we wouldn't actually be debating this bill, and I know that Hansard is going to record that this contribution was made on the 23rd of February, but I think that in fact, if I haven't got my diary on me, but I think we're up to the 25th, so which means that of course for Parliament, time stands still, and most people actually don't know that about the effect of the urgency motion. So the day stops on the day that the urgency motion is adopted by the House, and then we are essentially extending the sitting hours of the House so that even though we get to go home to bed at midnight and come back at 9 o'clock in the morning, in actual fact the Parliament shows itself as sitting on the 23rd of February. Normally speaking, I would be chairing the Commerce Select Committee, very, very good committee. I think other members of the House would agree that. Good deputy chair over there as well. So we have a very effective, and Charles Chauvel would be chairing the Regs Review Committee, and he's a very good chair of that committee. It's a very good committee as well. Oh, well, the point that I'm making is that there would be other business of the House being conducted in other forums if this wasn't going through under urgency. And I think Mr Mallard missed one essential point about the nature of this legislation. Even though we agree with Part 1, we were the government that introduced Part 1, and we're going to have a further debate about moving amendments under urgency to what is a constitutional bill. And that's the point that Mr Mallard didn't pick up on. This is a constitutional bill. Judicial matters bills always are. That's why the attorney sits in the chair. It is not a matter for the Minister of Justice, it's a matter for the attorney. So I'm very pleased that we are debating Part 1. But I'm also going to congratulate the attorney for having the integrity, the grace to say that after reflection of practice, the situation is different from how I expected it to be. But there's a little bit that just kind of sticks in my throat, just a little, and I thought I'd just cover over some of the things that the attorney said when he was of a different mindset. And essentially he said that, first of all, he talked about the ridiculous nature of the regime. He said that in 2004 National had opposed the substantive legislation. We said that it was an unwarranted attack on judicial independence and that it would encourage ineffective and stupid complaints. In fact, that it would encourage a culture of complaints. And then just later on in that same commentary, he said, of course judges can be rude, grumpy or discourteous. In many cases, one can hardly blame them, given the quality of submissions they have to hear from lawyers. But are we such a weak-kneed, sissy society that if a judge barks at us, we have to run off to some judicial complaints body? Well, I think that is spoken by a true list MP. If that member has never had a constituent in their office talking about how they feel about judges, and not just the decisions they make, but the way they're treated, how they're spoken to, sarcasm, no eye contact, all of the things that actually lead to a grievous sense of grievance. You know, it's much worse than it was at the beginning of the court proceedings. And I had such a constituent in my office last week, and I can understand how he feels. I also understand the message that the judge was trying to give, but a total disconnect, therefore a complaint. And I call this judicial complaints process as a steam valve on what would otherwise be a pressure cooker environment. And it is not for the lawyers that the complaints provisions exist. It is for the ordinary people who live on the street, who end up in a court environment and who find themselves on the receiving end of something more than just lack of grace, rudeness, grumpiness or discourtesy, but a complete lack of the meeting of the minds. And people often think that they can effect change by court proceedings, when I think the Attorney and I would probably agree that that is not possible. And so we have neighbourhood disputes ending up in our courts, which should never end up there. People wanting to prove that they are right when the other has to be proved wrong. The court isn't the place for those things, and the Judicial Complaints Commissioner has really helped in this process.
Mr. Chairman.